So viewers, this is my submission in terms of how I can explain the case. So a trial causing financial loss to the state usually will begin at the High Court. So assuming that Stan Dogbe is charged for defrauding by false pretenses, contrary to, you see, that's how they charge you. They will, because you see, they can't charge you for something that is not already written down, because the crime and the offense that you have committed must have been thought about by the lawmakers. So when the lawmakers sit down, it is predictable. So when you do something, there's something that you have done, the narrative of what you have done, they bring it onto the table, say what you have done, and see which one fits. So Stan Dogbe told Paul Adom-Otchere that he will buy him a yacht in Las Vegas. Paul Adom-Otchere parted with $50,000 to Stan Dogbe to buy the yacht in Las Vegas. Stan Dogbe was aware that at the time that Paul Adom-Otchere gave him the money, or at the time that he, Stan Dogbe, made representation before Paul Adom-Otchere that he is able to acquire a yacht for Paul Adom-Otchere, Stan Dogbe knew or ought to have known that he is in no capacity to buy the yacht. But Stan Dogbe nonetheless presented himself as one who is able to buy a yacht. So Stanislav Dogbe took $50,000 from Paul Adom-Otchere, and Paul Adom-Otchere's expectation was that he will be given a yacht in Las Vegas, so that when Asante Kotoko beat Hasselfolk, he will take the Kotoko boys to Las Vegas and put them on the yacht, and they will sing Kuma Pima Pimbeba, Kuma Pima Pimbeba, etc. Okay. So Paul Adom-Otchere goes to the police and says that, I have given Stan Dogbe $50,000 to buy me a yacht. Up to today, the yacht doesn't come. When I call him, he doesn't pick. When his PA picks, he's insulting me. So I don't know what to do. The police will say, what is the address of Stan Dogbe? I said, I have his phone number, 0244773333. Police call. He picks. Hello, are you Mr. Stan Dogbe? He say, why are you asking? Are you Mr. Stan Dogbe? What do you want? Hey, this is the Ghana police. Are you Stan Dogbe? He say, yes, I'm Stan Dogbe. Come to headquarters. Paul Adom-Otchere, Stan Dogbe is coming to headquarters, so meet us there with your lawyer. Stan Dogbe comes. Hey, Mr. Stan Dogbe, you have been reported about a case of something we think is defrauding by false pretenses, contrary to section so and so of the Criminal Offences Act. So that's the preliminary stages. So case Ato Forson would have gone through that preliminary stage. The police will now hand it over to the Attorney General, the government prosecutor. The government prosecutor goes to court. So they go to, because depending on the offense, you see, the law has decided that if it is stealing, you go to circuit court. If it's this, you go to that. Most of the high-profile offenses, you start at high court. Actually, there's no criminal prosecution that begins beyond the high court. There's no criminal prosecution, except, is that treason or something? I think all of them begin at high court. All criminal, high court and below, all criminal prosecutions begin at the high court. So he comes to the high court, like Ato Forson and co. The prosecution will start to make their case, okay? So they will say that you, Stan Dogbe, on so and so date, or let me use the actual actors. You, case Ato Forson, on so and so date, you did this and that and that and that and that. Prosecution, whatever they say, they will prove it. How do they prove it? So they invite their witnesses. Witness one, Godfred Yebo Adame. He comes. They call him PW1. PW means prosecution witness 1. Okay. So prosecution witness 1, prosecution would actually have to tell the court that I'm calling 7 witnesses. Prosecution cannot add an 8th except with permission of the court. The lawyers would like to confuse you. They say except with leave. Leave means permission. Don't worry about that. I'm here to help you, please. Don't worry about the lawyer's language. Everything they say, I understand. I will help you. Every Latin they say, I understand. I will explain. Don't worry. So when the lawyers say, you need leave of the court, then they can't. Did you get leave? They mean permission. If they know that if they say permission, you understand, but they want to be boss. So, yeah, permission. Forget about leave. So they need the permission of the courts to add an 8th person, because they have already told you, the defense, that they are going to call 7 people. So they can't call 8. The 7 people, they give their names to the court and their names to the defense. We'll be calling Anziba, Michelangelo, Apreku, and they will also tell the court that when Apreku comes, he will be asked questions about this and that and that. So the defense lawyers are already aware. So in case they say when Apreku comes, they will ask him about something called nomenclature. Defense lawyers will look at it and say, boss, what's nomenclature? Let's check the dictionary. They Google it. Oh, we understand. Okay, that's what there are no surprises in court. If you create a surprise, the judge can cancel it. no matter how valid it is, it ought not to be a surprise. I'm explaining the High Court criminal procedure. Okay. So all those things are not allowed. Surprises are not allowed. You can't surprise anybody in court. So as soon as you say something that they are not aware of, they didn't know you were coming to say it, they are not prepared for it, the lawyer will say, my lord, he's surprising the court. This was not in the brief. The judge will say, but prosecution wasn't in the brief. You can't use it. You didn't put it in the brief because you have to put everything in the brief. If you find something new in the brief, you file an application to the court that day. When you file the application that I want to add iPhone 17 evidence, the defense will be asked that do they agree? They will oppose the application. They may oppose the application. In fact, if they oppose the application and the judge doesn't listen, they can go to the Court of Appeal. Those are the things we call interlocutory applications. That is, applications that occur in between the beginning of the trial and the end of the trial. The trial can start and go on without any problem, without any interjection. But where there's an interjection, where the judge has to make a ruling, so all the decisions that the judge makes during the court is called ruling. At the end of the day, it's called the judgment. So the judge is required to make decisions on small things as they are going along. So an example, the guy comes to court one day and says that I am doing this. Prosecution says, no, my lord, you can't do that. He said, my lord, we oppose the application. Why do you oppose it? My lord, contrary to Article 16 of the Republican Constitution, he's not able to do that in a criminal trial. The judge says, give me 3 days to look at this. That's how the cases delay. So the judge takes 3 days, comes back and said, my ruling by court, I rule that the paper that he was trying to adopt and submit, it is taken. When it is taken, the one who has lost it can say that, my lord, I don't agree with you. I'm going upstairs. So he files an application on only that one to the Court of Appeal. When he files the application, because these days there's been complaint from the Bar Association, civil society, interlocutory applications are guided in a certain way. So when he files, the judge can say that you can file your appeal, but I'm continuing with the case. If the lawyer feels that continuing with the case will hurt him, he will file what they call a stay of proceedings. In filing the stay of proceedings at the High Court, he will tell the judge that it is meritorious and it is fair that you wait for me to go to the Court of Appeal to hear this decision before I come back. The judge can say no. When the judge disagrees with the stay of proceedings, he is most likely to go on with the case. That disagreement of the judge of the stay of proceedings can also be appealed against. So you go to the Court of Appeal and say, I filed a stay of proceedings. The High Court judge says he won't listen. 3 Court of Appeal judges will listen and they can tell the High Court that the stay of proceedings has been granted. Or the stay of proceedings was not granted. If the stay of proceedings is not granted at the Court of Appeal, on that small matter, he can go to the Supreme Court. And the Supreme Court, 5 judges will sit and say, we have granted it, we haven't granted it. If they don't grant it, he will go to Supreme Court review. Now, who is the master of that? Chachu Chikata. He's the master of interlocutory applications. He is the Maradona, the Pele of interlocutory. Oh, Chachu, small thing. Oh, my Lord, I'm going to the Court of Appeal. I will not accept this. I go to the Court of Appeal. He goes to the Court of Appeal. He says, I agree with the High Court. Oh, no, my lords, I'll test it at the Supreme Court. He goes to the Supreme Court. It's a Supreme Court review. That's my Lord, Mr. Chikata. So I'm just trying to explain. I'm coming to tell you what happened today. So this matter is at the High Court. Prosecution, when the prosecution finished their case, everything they say they have to evidence it, bring witnesses and all that. When they have closed their case, they will tell the judge that, my Lord, this is the end of our submission. We are finished. This is the amount of evidence we have against the accused person. This is all the evidence we have presented against the accused person. It is now time for the accused person to open his defense based on everything we have said. Accused person stands up and says, my Lord, everything they said, they didn't say anything. Now, what is that based on? It is called a submission of no case. It is the accused person saying that from all what they have said, they have not been able to show that there's a case for us to answer. How do they do that? They do that based on what we call the ingredients of the offense. So every offense has ingredients, like food has ingredients. So stealing has ingredients. First of all, you must show that an item has been stolen. 2, or money has been stolen, or something has been stolen. 2, you must show that the person who stole the thing, it didn't belong to him. You must show that this and that and that and that. So for instance, you say I've stolen a mobile phone. And then I come to court and I say, the mobile phone you say I've stolen belongs to me. So when you are finished doing your case, I tell the judge that I'm submitting for no case. The mobile phone they say I've stolen, it is for me. How can I steal my own thing? The judge will say, yes, you are right. Submission of no case granted. prosecution, you have not been able to make any case against Paul Adom-Otchere. Adom, good night, and God bless you. And I go, then they pour powder on me, then I do, allow me to kiss your hand. So that's submission of no case, by the way.